right. Hello, everyone. My name is Zoe Frost with Celebration Magazine Live, and we are here today for a very, very special Zoom and Learn with our friends at McGee Law Firm. We had 80 people register for today, and I'm going to introduce Brandon here for you. Brandon L. McGee is the co-owner of the McGee Law Firm. He was born and raised in Dallas, Texas, and he attended Texas Christian University, where he earned his bachelor's in 1998. He graduated from Emory University School of Law in 2001, and he is a member of the State Bar of Texas, the National Academy of Elder Law Attorneys, and is the only DFW member of the prestigious American Academy of Estate Planning Attorneys. All right, Brandon, take it away. The floor is yours.
Okay, thank you guys. And Mitch is going to help me get the share screen up. Make sure we're in good shape here. Okay, does that look good?
Yes, it does.
Perfect. Okay. So guys, today we're going to talk about trustee and power of attorney school. And one real important kind of overriding theme to remember here is that we're looking at situations where you would need somebody to step in and handle things for you. Okay. And these two situations, none of them are ones that we look forward to. One, of course, is passing away. If we pass away and we leave assets behind, a house, car, bank accounts, retirement, those kind of things, we need somebody to step in and distribute those assets to the proper people who we normally call beneficiaries. A second scenario in which this could happen would be if you are alive and well, or alive, but you're mentally incapacitated, meaning you've reached a point for one reason or another where a doctor, most people in society would say that you cannot make good, rational decisions for yourself. So kind of keep in mind, that's what we're talking about today, is the different legal documents that we have and the different powers that we have to handle those two situations. So that's just a little bit about me. You guys just heard about me. So that's just it there in writing on the screen, okay? The American Academy that I'm a member of, it's an exclusive national organization, which means that not any attorney who wants to can join. We're highly vetted before we're allowed in. And as you were told, I am the only DFW member. So it's a great organization that gives us a lot of value and support that we're able to pass on to our clientele. NALA, National Academy of Elder Law Attorneys, another great organization I'm very proud to be a member of that gives us a lot of support. We're also a member of the Better Business Bureau, where we have a A+ rating. And the most important reason that I'm an estate planning and elder law attorney, that's a big question, because as you guys know, as an attorney, there's a lot of different things that I could be doing, right? We all know about criminal defense, prosecutors, there's bankruptcy lawyers, divorce lawyers, corporate attorneys, all sorts of attorneys out there, just like there's all sorts of doctors. And I'll just tell you briefly, I was a litigator for about the first, 12 years of my career, 10, 12 years. I was a courtroom attorney, and that's what I wanted to do since I went into law school. It sounded fun, it sounded exciting, and it was fun and exciting for a time. But as time went on, I had my own family, who you see here in the screen. I have twin sons who are now 12. This picture is a couple years outdated. But in the year 2012, as I was sort of starting to get a little bit burnt out on my courtroom experience and all the stress that comes with that, my wife, Rita, at the age of 39 at the time, in May of 2012, she was diagnosed with stage 3 breast cancer. Rita's also an attorney. She's a real estate attorney. So I was running my practice. She was running her practice. Our twin sons were about to turn 4. We already had our hands full in life to begin with. And so this was an issue, a diagnosis that if any of you guys have experienced it in your family or yourself, you know how shocking it can be, particularly at a relative young age, like 39, when you're in the middle of raising your family. So Rita had to start chemotherapy immediately, went through a lot, different surgeries and so forth. But about 35 days after Rita was diagnosed, my father passed away at the age of 64. It was July 1st, 2012. He was in his backyard in Dallas, and he was doing yard work and collapsed. And from what my mom says, probably 10 to 15 minutes later, by the time the ambulance got there, he was gone. So within 35 days, I had lost my father very shockingly and unexpectedly, and my wife had stage 3 cancer. So of course, during this time, I did a lot of reflecting over the next few months, the remainder of that year. And that's when I decided that I really enjoyed the estate planning aspect of my practice, really getting burned out on the litigation aspect of my practice. And the reason I enjoyed estate planning is because I consider it to be preventative law. Just kind of like we have preventative medicine, where you do certain things so that you keep your body in as good of shape as possible to try and prevent problems from happening. Estate planning is similar to that. It's preventative law. We want to get things done so we have a healthy estate plan, so that when things come up in life, our family is in the best shape possible to handle those things. And so I made that decision about 8 years ago. Great decision, one of the best I've ever made. And that's why I'm an estate planning practitioner. I've been through a lot of things that I counsel my clients on, serious diseases, family members dying. Right now I have a mother-in-law who we're having to transition into either assisted living or skilled nursing. So I'm going through that right now with my mother-in-law. And I think it puts me in a good position to help guide others. And very happy to say, and most importantly out of all this, is my wife has been 8 years, no evidence of disease as of this month. So very happy to report that. Now, enough about me. Let's get into the meat of the matter here. Number one, if you have questions, I will have a question and answer at the end. We'll do about a 10-minute question and answer. Also keep in mind, we're also always available for a free initial consultation. So and of course, since COVID's hit, we've been meeting with a lot of people by Zoom, over the phone. Some people do, a lot of people still want to come in the office, and we take a lot of protocols with that. But keep in mind that all of you guys can take advantage of that free consultation, and we will have a 10-minute question and answer as well at the end here. So estate planning. We look at a lot of different things when it comes to estate planning, and we really look a lot at your family. So whenever a client comes in, we spend a lot of time talking about your family dynamics. Everybody is so different. We've got a lot of nuclear families. We have a lot of blended families. We have blended families that get along great. We have blended families that don't get along. We have nuclear families sometimes that don't get along. So we always want to get a really good sense of your family dynamics. We want to develop a relationship with you. And then from there, we get into the business of the documents that might work and be a good idea for your family. Okay. And it's important to remember too, that well-drafted estate planning documents, well-drafted being a key here, can save your family a lot of time, a lot of money, a lot of headaches, and court involvement. So that's one of the big reasons that we do this, because the court system is always there. If somebody just completely fails to plan, doesn't do anything, they have no estate plan, and they pass away or they become mentally incapacitated, in Texas, we have a court system that will handle that. But it's going to cost you or your family a lot of money. It's going to take a lot of time. You're going to have to deal with a lot of judicial and government red tape. And it also will open up a lot of times the situation to family feuds and family fighting. So what do we consider to be a comprehensive estate plan? So at our firm, we look at having a living trust, or if maybe somebody doesn't have a strong need for that, maybe they have very limited assets, we'll look at a last will and testament. That's what will dispose of somebody's assets after they pass away. And really for passing away, those are the primary documents that you would need. Now, when it comes to managing somebody who becomes mentally incapacitated, managing their estate. So if somebody gets Alzheimer's, if somebody has a massive stroke and suddenly, you know, one day to the next, they've lost their mental capacity, there's things that their loved ones we're going to need to do for them. So we have property power of attorney for real estate. So somebody can step into your shoes and handle your real estate. We have a statutory durable power of attorney, which is going to be for managing finances primarily, retirement, bank accounts, tax issues, things like that. Then we look at the medical, right? We have to have medical managers as well. So we have a healthcare power of attorney for managing medical decisions. We have a HIPAA release form, which is going to be so that the medical power of attorney can get the medical records. And pour over will, that's something that goes with a trust. I'm not going to get real into that. Advanced healthcare directive, that is something that a lot of my clients, it's also called a living will. You might have heard that. It's kind of the informal term. A lot of my clients, particularly seniors, are very interested in that document. And that's where you can predetermine matters of life support. So if you're on life support, certain dire circumstances, such as the doctor feels that you're, you know, there's a really good chance here that you're going to pass away fairly soon, or you're in a state where maybe you've had so much damage that you're never going to be able to come back to the person that you were and care for yourself and have your mental capacity, things like that. You can elect whether you would want to remain on life support or be removed. We also have another document that we consider to be critical is disposition of, it's authority for disposition of last remains and burial instructions. Now, a lot of my clients will say, well, I've already got a burial plan, and that's great. That's very good. I encourage people to do that or to get a cremation plan ahead of time. But we also need that authority for somebody to deal with the burial company or the cremation company. And if you're married, that person is your spouse. They have the automatic right to do that. But in the state of Texas, if you're not married, then they're going to go look to your children. And if you have 3 kids or 4 kids and they can't agree on should you be buried, should you be cremated, we got a problem. So all the kids are going to have to agree. So the authority is where you predetermine your choice of who's going to handle that. And you can have as many choices as you want in terms of a succession. So you can have my spouse, then kid number 1, kid number 2, kid number 3. But we always have that one person who has the authority to handle it without having to deal with arguments with other family members and things like that. Declaration of guardian, that's kind of the backup plan. The goal of these powers of attorney here, the healthcare, the property, the HIPAA release, is so that if you do become mentally incapacitated, you are not going to have to go through the court system. Your family can immediately take these documents, go to the doctor, go to the bank, and start doing business. Okay, that's the goal. But with the declaration of guardian, that's in the event that you don't have these documents or these documents fail. Now, why would these documents fail? Number one reason is people not getting them what we would call refreshed enough. We recommend about every 5 to 6 years that you redo your powers of attorney because the laws can change fairly quickly. That's not a certainty, it's just a recommendation. It's an observation from us over time that our clients who get them redone about every 5 to 6 years, very rare for one of them to call and say, hey, this didn't work, and they're not going to accept it. But the declaration of guardian is there. If your family has to go through the court system, you will predetermine who will be your guardian, who will make your medical decisions, who will handle your finances. And this is real critical, just like these other documents, because it really cuts out the possibility of a family feud. We have seen, unfortunately, a lot of bloodbaths here in the court system in DFW over who's going to be in charge, who's going to get this, who's going to get that. And you can imagine sometimes there's a family member, maybe an adult child that doesn't have good intentions. They just want access to the money. And so this is where you can predetermine who you think is best, and that person will serve. Here you'll also see where it says motor vehicle. We have beneficiary designation forms for motor vehicles. And basically it's like this. If you fill out the DMV's motor vehicle beneficiary form, you put it on file with the DMV. On that form, you're going to have your beneficiary for who will inherit your car title when you pass. And it makes that a very easy, smooth transition from one family member to the next. I've had people that have had to come hire me to probate a last will and testament just so they could get ownership of a car, and that's very frustrating. So we always recommend that for our clients. Deeds, we have transfer on death deeds now in the state of Texas, and that's for real estate, and that's where you can leave a beneficiary behind for your real estate so that when you pass away, your family does not have to go through the court system to become the owner of your property. For many years in the state of Texas, the only way to transfer ownership of real property after death was to either have it in a trust, which a lot of my clients do, or to have, or to go through the court system. Now we have a third way. We don't have to have a trust, and we don't have to go through the court system if we have a transfer on death deed. And that was established in the year 2015 here in Texas. A couple of really important things to remember here about all these documents is it is my strong recommendation that you work with a Texas-based attorney for these documents. We definitely do not recommend relying on out-of-state documents. If, you know, here in DFW and all the big cities in Texas, we have so many people moving in from just all over the place daily, it seems, and from all over the country. So it's real important to get Texas-based documents, as there are 50 different legal jurisdictions when it comes to estate planning. Each state has their own jurisdiction, their own laws, etc. It's also important, in my opinion, not to do these documents yourself. There is a shortcut. You guys may have seen ads for this. You may have done it, but there's do-it-yourself type document options out there, and I don't recommend that at all. I've had people come in, fortunately, before something happened, and with those documents, and there's numerous reasons they're not going to work, and we're able to get that straightened out. I've had other people come in after a family member has passed away, and they have those documents, and it's too late. Either the documents aren't right, they're not Texas documents, or maybe they just weren't executed properly. We don't have the proper number of witnesses. We don't have a notary. So we recommend, just kind of like, you know, there's a value with your health going to your doctor. You know, you don't have to go to a doctor. Nobody's going to make you, but we generally recognize there's a value to having a doctor, you know, once a year, take your blood, run it through tests, you know, test out different areas of your body that may potentially be problematic, and then have that professional determine what you need to do. We believe the same holds true for estate planning. Big mistake is not having an estate plan at all. Like I told you, you don't have to have an estate plan at all, but you're going to leave your family in a position where they are going to go through the court system here in Texas. The worse the estate plan is, or the complete absence of an estate plan, the more expensive it's going to be, the more of a headache, the more time it's going to take, and again, the more of a potential for family feuds, family disputes, which is something that when I talk to my clients that come in, that's a big thing they want to avoid, or family problems after they're gone, or if they become incapacitated. Okay. Same thing with neglecting to plan for incapacity or disability. And again, just to make this real clear, when it comes to incapacity, the cure to that is powers of attorney, both medical and the financial ones, the property ones, all the lists that we had on the screen a couple screens ago. That's going to be the cure there. And it's real important, in my opinion, to have those refreshed about every 5 to 6 years by a Texas attorney. It's my recommendation to do that. So again, not having a power of attorney means that if I go out here and I get on, you know, I-30 or I-35 or 121, and I'm in a terrible car accident and I have a bad head injury, and maybe I'm in a coma, and I'm in the hospital. If my wife doesn't have these documents, even though she's my wife, she cannot make my medical decisions. She cannot get my medical records and go to another hospital and get a second opinion. And likewise, she cannot sell our house. She cannot sell my car. She cannot access retirement accounts in my name. So real important to have these documents, even if you're married. A lot of people, there's a common misconception that, well, if I'm married and a lot of times the husband will say, well, I know I'm going to die first, and Something's going to happen to me before her. And she's my wife, so she just gets everything. She can just handle everything. That's not the way it is in the state of Texas. It still requires going through the court system if you don't have the proper documentation. And of course, it's even more of an issue if you're single or widowed and you're leaving kids behind to handle things. Okay. Public process, again, which is going through the court system for guardianship. This is if you're mentally incapacitated. It is expensive. And trust me on this, because I also do this. I help out families who have to go through the probate court system. They come hire me to go to guardianship court or to go through the probate court system when somebody's passed away. So I see both sides of this. It is always more expensive to go to court than it is to set up the documents properly with an attorney, always. Not only is it more expensive, it is more time consuming. It is a big hassle. It is a headache. And it can also sometimes be embarrassing for the incapacitated person, because this is not always a black and white issue, right? It's not always, well, either, this person's doing great or they're just completely out to lunch. There's that middle of the road there, particularly when it comes to things like dementia, Alzheimer's, where it's not really clear if the person has mental capacity. They may have good moments and they may have good days and they may have bad days. And a family member comes in and has to apply for a guardianship on their behalf. That person may have to be wheeled into the courtroom. They may have to answer a bunch of questions in front of the judge. They're going to be looked at by a guardian ad litem appointed by the court. They're going to be looked at by a doctor. And all these people are going to be analyzing them and giving opinions in a public courtroom about their mental state. And I mean, it's one thing to think of that in the abstract happening to somebody else, but we wouldn't want to be in that position. It could be humiliating. We wouldn't want one of our parents to be in that position or our spouse to be in that position either. So good reason to get your affairs in order. So another good reason so that we can avoid the court system. Okay. Another big problem that we have in estate planning is no nursing home protection. And what I mean by that is that if you look at the cost right now of long-term care, which, like I told you, we're having to look at with my mother-in-law at the moment, it's getting really expensive. Skilled nursing is getting really expensive here in DFW. Assisted living is getting up there as well. And there are some things that can be done to plan for that, so that if you have to do that, your spouse has to go to assisted living or skilled nursing home, there are funds there to pay for that without having to just write $7,500 checks every month out of your estate until you basically go broke, and then you can apply for Medicaid. So I know a lot of you have probably heard of Medicaid. Some of you may know a lot about it. Some of you may not know much. But to keep it kind of general, you have to be pretty close to being broke before they'll let you on Medicaid. But there are things that we can do with estate planning to set the estate up so that the family can qualify if they need to, without going broke first. Okay. So that's something very important. And I just want to encourage all of you guys, if that's a concern of yours, some people have, insurance, long-term care insurance. And if you have a good long-term care insurance policy, I'd say you probably don't need to worry about it. If you don't, this is something you need to start thinking about, because there are families in Texas every month, every week, that are losing hundreds of thousands of dollars to a nursing home stay before the family member can qualify for Medicaid. But if we set things up ahead of time, we look at this ahead of time, then the family can go ahead and get things set up to avoid that. Okay. Again, the DIY, that's the do-it-yourself mistake. I just do not recommend drafting your own legal documents. I gave you the analogy of the medical field, right? I'm not going to start diagnosing myself by getting on WebMD and then going to Walgreens. That would be a bad plan for my health. If my AC breaks in my house in the middle of August, I'm honestly not going to try and fix it. I'm going to hire somebody who, that's what they do every day. That's what they've been trained to do. They pass a test to do that. If my car breaks down, likewise, I'm going to take it to an auto mechanic who's qualified to handle it. Same thing with legal documents. Okay. Must-have documents. So we talked about some of these earlier. For the powers of attorney for managing your estate, your assets. I realize estate sounds like a big grand thing, right? So I try to kind of avoid using the word estate, although I just accidentally used it. But estate does not mean that you are a Rockefeller or a Bass or Bill Gates or Warren Buffett, right? An estate is just what you have. If you own a house in Richardson and you have a car and you have a 401k and a checking account, that's an estate. You have an estate. But the powers of attorney allow somebody to manage your assets, manage your estate if you become mentally incapacitated. So it means they can immediately step in and handle those things, such as a spouse or an adult child, without having to pause and spend months and months and months and thousands of dollars in the court system, potentially fighting with another family member over that role. So very critical to have, okay? There are two different types of powers of attorney. There's immediate and there's springing. Immediate means that as soon as I sign it, that person has the legal authority to do what they need to do to help me. Springing means the document's there, but it doesn't take effect. They can't use it unless a doctor puts in writing that I'm mentally incapacitated. And that's something that we sit down and talk to our clients to. We talk to them about that and try and determine, which way is best for that family. It depends on a whole lot of circumstances. So again, immediate power of attorney, for example, 85-year-old widow who does not really like to get out and about and handle things any longer, but she has a daughter or a son who lives 10 minutes away, who handles a lot of things for her or for him. You might want to make it immediate so that they can just get things done for you when you don't feel up to it. Springing means that you're doing good in life, you're handling your business, it's not a problem. You want to keep doing it as long as you can. Then that document would take effect, that power of attorney would take effect later on down the road if you do lose your mental capacity, okay? And so you might also hear the term attorney in fact, and a lot of the documents will say this. That's the same thing as power of attorney. So your power of attorney is also your attorney in fact. They're interchangeable terms. And if you look here in the middle of the screen where it says Mary J. Smith by Eric S. Smith, her attorney in fact. This is where Mary's son, Eric, is going to be signing documents on her behalf. And that's the way that you do it. You simply, so if you're serving in this role for somebody, you simply say Mary J. Smith by Eric Smith, yourself, her attorney in fact. And that's how things, legal documents, checks, and so forth will get signed if you are somebody's power of attorney. Okay, so post-death power of attorney doesn't exist. So if my mom loses her mental capacity and I spend 3 years using a power of attorney to manage her bank accounts, receive income on her behalf, all those kind of things that need to be done. The second I know that she has passed away, I can no longer use the power of attorney. And if I do keep using the power of attorney, that could potentially become fraudulent. So it can be dealt with under the law. And so it's important to know that as soon as somebody passes away, you can no longer use the power of attorney. Sometimes I'll have somebody come in and say, well, my mom died and she's got, money with Charles Schwab, she's got money with Bank of America. I can just use the power of attorney to go get all that money, right? And the answer is no, absolutely not. You have to then move to either doing that under the trust, or you need to go probate her last will and testament and access the money that way. So power of attorney dies when the person dies. That's very important to remember. Healthcare documents, like we said, we have the healthcare power of attorney, the HIPAA release form, and what we call the living will or the advanced healthcare directive for when people are on life support to make those decisions. And the healthcare power of attorney, the agent is somebody you're going to select that's going to make decisions for you. All of your healthcare decisions that need to be made, anything from should you or should you not have the surgery, what hospital should you be in, what doctor should be treating you, what, if you need skilled nursing care, which facility are you going to be in, all of those kinds of things. Okay, you also need to have HIPAA. This was a federal law passed around a decade ago that says that even if you're a power of attorney, you cannot get somebody's medical records unless you have this specific language in this specific form. And it's very important so that you can go to different doctors, get different opinions if you need to. So if you don't have HIPAA, you're not going to be able to get the medical records. And so, for example, if I'm at Baylor, Scott and White in a coma, and my wife's my medical power of attorney, but she doesn't have HIPAA, she is just stuck dealing with Baylor, Scott and White. She's not going to be able to get my medical records from Baylor, Scott and White and go to another hospital and get a second opinion. Now, unlike financial powers of attorney, which the statutory durable and the property that die when the person dies, the healthcare documents are good for 50 years following the date of the death of the person. Now, you might ask, why in the world is that? The person's gone, they're buried. Why do we need to make healthcare decisions for somebody in that state? And the reason potentially is going to be, for example, lawsuits may come up, right? There might be, somebody may have a medical malpractice claim and they're going to need to get healthcare documents. Other reasons for that could be if there's a dispute over medical bills that are due and owing after the person passes, and you want to get all the medical records from that hospital. So there is 50 years, quite a long time, right? That will still be in power after the person passes. Now, a lot of people will hear the term living will, and the people will hear the term will, which is a last will and testament, and they'll get confused between these two and maybe kind of mix them together or cross them up. Really simply, a last will and testament tells the court who to name as the executor of your estate after you pass away. And it also says who's going to get what from your estate. It's going to name the beneficiaries. And then when we have a living will, the living will is simply going to dictate, if we are on life support, what is going to happen in certain extreme scenarios. Okay, so am I going to be somebody who wants to stay on life support until I'm gone, no matter what, or am I somebody who is going to want to be removed under certain very extreme scenarios? Okay, so here's a little bit of information, a little bit of further information. A living will can also be called an advance directive, doesn't require going through probate court. A last will and testament does require to go through probate court. Okay, so I have a lot of people that will say, well, I have a will and it just says when I pass away, everything goes to my kids. So that should be easy. They just get everything when I die. And that is not correct. That's a very common misconception. A last will and testament requires you to go through the probate court. When you pass away, what you can have that can allow your family to avoid probate court when you pass away is going to be a living trust, for example. That's something that we use in lieu of a last will and testament so that we don't have to go to probate court. Other things that I told you about earlier, the transfer on death deed for real estate can help us with that. Other things that we have are going to be the beneficiary form for the Department of Motor Vehicles. That's another one. So there are things out there that allow us our family to avoid probate court after we pass away. So we generally want to let our clients know about those things, let them choose if that's what they want. But a last will and testament does require us to go through probate court, so keep that in mind. Declaration of guardian, we talked about that earlier a little bit. That's going to be if you don't have powers of attorney, or if maybe your powers of attorney are 12, 15, 16 years old and you never got them refreshed and they're denied simply because the legal language has become obsolete and they're not accepted by the bank, they're not accepted by the hospital, then declaration of guardian is what we're going to use to go through the court system so that we can become the legal guardian of that incapacitated person. And it's going to have the choice of guardian by the individual. And the really good thing about that is if you have to go through court, at least it's going to stop family feuding, family fights, things like that, okay? So anyways, there again, guardian allows you to name your person of choice. We'll normally name 2, 3, 4, how many ever you want in order of preference in case other people pass away, other people they moved to Japan, they're too busy in life, they don't want to do it, they want to let somebody else do the job, okay? Also I know that I think you guys are a senior group, but this could be something that you could pass along to your adult kids who have children, your grandkids. We also, for my clients like myself who are still in the phase of life that we have minor children, we have a guardian for minor children as well, so that if mom and dad are going on a date one night and they're driving home and they're wiped out by a drunk driver and that's it, they're gone. We at least have in place the parents' preference for their first, second, maybe third choice of the family members who would be the legal guardians of the minor children. So that way we avoid arguments within the family about, who's going to be taking care of these kids and raising these kids and so forth. There's a lot else that goes along with that too, a lot of financial things that we need to take into account. We have documents for those, for that as well. I won't be getting real into that though today. Appointment of agent to control disposition of remains. This is the one where I told you where in the state of Texas, your spouse has the automatic right to control your last remains. But after that, it starts going down the family tree. So if you have 3 kids or even 2 kids and they can't agree on where you should be buried, if you should be cremated, if you should be buried, then we've got a problem, right? And Carol Shelby, who you guys, if anybody saw Ford versus Ferrari or has been a big fan of the Mustang car for a while, he was a very innovative, influential developer of fast cars, of race cars a few decades ago. This happened to him and his family. His kids had a big, long, months-long dispute over his final remains, and his body just had to sit there in the morgue until they figured it all out. So that's what we're trying to avoid with the appointment of agent to control disposition of remains. Okay. There's a little kind of regurgitation of some of the things that I've told you there. What happens to your car when you pass? So at the beginning, we talked about the motor vehicle beneficiary. The Texas Department of Motor Vehicle has a beneficiary designation form that we highly, highly recommend that you fill out, name a beneficiary, and put that on file with the DMV. That makes it so much easier for your family member to transfer title after you pass away. Now keep in mind, you can only do this if you outright own the car. If you lease a car, it's not necessary. Or if you're making payments on a car, you probably don't have title yet. But we keep a big stack of these at our office. We give them to all of our clients and highly recommend them, but you can also get them through the DMV as well. Okay. And because a car carries legal title, if you don't have this document, chances are pretty good you are going to have to go through the court system to become the owner of a car. Sometimes a spouse, if they can bring to the DMV their marriage certificate, their license, the death certificate of their spouse, sometimes they can get it done without going through the court system. Children have a much harder time with that, the adult children. So we just recommend filling out this form and putting it on file. It's just a much better way to do things. Okay, so real property deeds, transfer on death deeds, ladybird deeds. These are the things that allow us since 2015 in Texas to leave our real estate upon our death to the family members of or the beneficiaries of our choosing. And like I said, it used to be, and you'll see down here, changing title to trust. If you do have a trust, you need to deed your property in the name of the trust. You need to use an attorney for that. But if you don't, and you're not going to get a trust, we highly recommend the transfer on death deed or ladybird deed. Otherwise, your family will have to go through the court system, spend thousands of dollars, wait months and months before they can become the owner of your property and sell it or do whatever they are going to do with it. Roles and decision-making authority. So like I told you earlier, a power of attorney is also an agent, an attorney in fact. And so this is somebody that, just think of it this way, they're going to step into your shoes and do the things you normally do for yourself. You normally choose your doctors. You normally go get your, prescription at Walgreens. You normally decide if you're going to have a surgery or not. You normally talk to your financial planner and determine how you're going to invest your money. You normally, go to your bank and make deposits. You normally pay your bills. All of these things that you normally do, you need to have a power of attorney in place so that somebody else can do it for you if you become incapacitated, or else your family's going through the court system, spending a lot of money, a lot of time, and a lot of hassle. So with a trust, and keep in mind, a trust is a document that, like I said earlier, it allows us to avoid probate court completely. I'm a big fan of trust. Not everybody is, but a lot of people are, especially people that have had them, or they've been the trustee of their parents' trust, and they see how easy it is. It allows you to completely avoid the court system. It also allows you to avoid the federal estate tax, and it can also serve to allow beneficiary distributions that are not all at once. So most beneficiaries, if you go through the court system and you have a will or you don't have a will, they get everything they're entitled to in one lump sum. A trust can stretch out payments over years and years and years. So for those people that may need that for certain reasons, people have things going on in life sometimes that, or there's at a point in their life, it's just not a good idea for them to get a large inheritance all at once. The trust can help with that. And the trustor are the people. The trustors will be the people or the person who sets up the trust, who owns the trust. The trustee is going to be the person or the people who manage the trust. They enact the rules of the trust. And successor trustee is going to be the backup. So that may be an adult kid, that may be a close friend or family member, but that's the person that after you pass away or after you become mentally incapacitated, they're going to be in charge of managing the trust and doing the things that the trust says, following the rules of the trust. Okay. Transition to successor trustee. So you could have some people who are just unwilling to do it. And this is why we usually recommend getting multiple options. I usually like to have about 3. Somebody may die, somebody may become incapacitated, somebody may, become to an age in life where they just don't feel like doing it. Somebody may be going through a terrible divorce and they don't feel up to it. Somebody may get a job in another part of the world, another country, and they can't do it. So we want to have numerous options there, so we can make sure that somebody will be hopefully willing and able to step up and do the job. Okay, now executor. You guys have probably heard this term before. Just like a trustee operates under the trust and does all the things that it says to do in a trust, the executor is the person who is named in the last will and testament to do all the things that it says there, which is namely going to be liquidate the assets, sell the house, sell the car, liquidate the bank accounts, and distribute all those assets to the beneficiaries named in the last will and testament. So this is the person with that job, that important job of making sure those things get done, paying any estate taxes if those are due, paying debts to debtors or to creditors if those exist. And this person has to go through the court system. They're going to have to go hire an attorney, spend several $1,000s, spend months in the court system. Then they get the authority to be able to do those things, okay? But let me tell you this, even though I'm a proponent of the trust or the transfer on debt deeds, I'm a big proponent of finding a way to avoid having to go to court. All of my clients have a last will and testament, at least as a backup. Some have it, that's what they want to have, and that's just what they have. But everybody should have a last will and testament, because it is so much better to go through the court system with a will than without. It's less expensive. It costs about half as much. It takes about half as much time, and it's about half the hassle. So we strongly recommend a last will and testament drafted by a Texas attorney for Texas residents. Letters testamentary, letters of administration. These are terms you might have heard of, or you may have dealt with this if you've probated on behalf of a family member. These are the documents that allow that person who's been appointed by the court under the will to actually go out and do the things they need to do. So it's one thing for example, if my mom passes away and I need to sell her house, the title company's not just going to say, well, okay, you told me that you probated your mom's will. That's good enough for us. We'll allow you to sell her house and do this transaction. They need to see actual specific documentation from the court, granting me the authority from the court to sell the house, to go to Fidelity or to go to Edward Jones, go to Bank of America, access the money. I need these legal documents or I'm going to be denied. So it's real important to remember that as well. And these are the documents we get from the court when an estate needs to go through the court system. Okay. So some takeaways here. And again, I also mentioned this right at the beginning because I think it's very important to understand the powers of attorney. Okay. That applies when somebody is alive but mentally incapacitated. When that person dies, the powers of attorney die. Okay. Now, what do we do after the person dies? Again, let's take the scenario I mentioned earlier. My mom's power of attorney for 3 years and she's incapacitated. I'm making her medical decisions. I'm handling her finances. Then my mom reaches a point to where she passes away. I immediately can no longer use those documents. What do I have to do now? How can I sell her house? How can I get to her bank accounts, her financial accounts, and distribute those to her beneficiaries? That's either going to be as my role as a trustee, if my mom set up a proper trust, or it's going to be by my role as executor if she left behind a last will and testament. So those are the things that the documents that we need to handle people's property, people's medical decisions, depending on their different phases of life. Okay, so I talked a little bit about this earlier, but a living trust is a legal document that really is kind of magical. It's by far the most advanced and powerful estate planning document we have in Texas, and I would say in the US in general. It allows us to completely avoid the probate court process. Okay, a lot of time and money saved, a lot of headaches saved. It allows us to avoid the estate tax. It allows us to have beneficiary distributions that are not just lump sums. You know, if somebody is immature, if somebody is young, if somebody is in a rough marriage, if somebody has chemical dependency type issues, and we just don't feel comfortable giving them large sums of money, we can give them money over time rather than all at once. So those are some of the great things that a trust can do. An irrevocable trust can do all of those things I just said. Okay. Plus, this is the device, it can help us qualify for Medicaid even though we're not broke. And I'm not going to get in super detail with this today. This is something if you want to come in and talk to me or have a Zoom consultation, I'm happy to tell you all about it. But when you have an irrevocable trust, in addition to avoiding probate court, the estate tax, having a beneficiary designation that goes on for years and years, we can also set up our assets so that Medicaid can't count them. So if I have $500,000 in financial accounts in an irrevocable trust for 5 years or more, so it hasn't been there for 5 years or more, Medicaid can't count those assets. They have to say those assets belong to that trust. They don't belong to Brandon. And then I can qualify for Medicaid even though I have a trust with $500,000 in it. So this is also kind of I consider it to be one of those magical legal devices that can do a lot of really positive things for us. But it is irrevocable, okay? You can't revoke it. You can't change it. It's something that you don't want to get into until you've talked to an attorney such as myself who works in this area of the law and understands it well. What is funding? If any of you have ever heard the term funding when it relates to a trust, that's how you connect your assets to a trust, or maybe we can look at it as put your assets in a trust. So if I have a trust, the best drafted trust in the world over here, and then over here on the right, I've got all my assets. I've got my house, my bank accounts, my retirement accounts, you know, a lake house, rental property, things that people have. I actually have to put those in the trust. There's things that need to be done to connect them to the trust, to put them to the trust. Otherwise, the trust is useless. It's just a nice, pretty document that never does anything or accomplishes anything. So we have to have that connection between our assets and the trust, and that's called funding. And that's something that we take a lot of care to assist our clients with to make sure that gets done the right way. So again, taking assets that are titled in the individual's trust. This is something where with funding, we need to retitle assets at times. With property, we need a new deed that's going to retitle the property in the name of the trust. For financial accounts, we can either retitle them, or we can just simply do a death beneficiary designation to the trust, and then they'll go into the trust when the person passes. And again, it's something that needs to be done with the help of an attorney. What is a pour-over will? So a pour-over will is something that is what we call a safety net. So I told you I want all of my clients to have a last will and testament. A pour-over will is what my clients have when they also have a trust. And that's in case they don't fund properly. So for example, if my client gets a trust and they connect all their assets into the trust, and then they got a bank account 5 years after they set up the trust, and they forgot to connect it to the trust, the will is there to run that one asset through the court system in a manner that's going to be much less expensive and much less time consuming than not having a trust. So somebody just has a will, is that okay? Well, number one, it's a lot better than not having a will, okay? So I want to be real clear about that. But number two, I want to encourage you guys to explore other ways to avoid the court system, because again, the will send you to court, albeit cheaper and quicker than not having one. So everybody please have a last will and testament drafted by a Texas lawyer, and everybody please explore the possibility of setting up your estate in other ways to avoid that, okay? Now time passes and passes, and you set up an estate and several years go by, and then somebody passes away. What needs to be done? So if somebody has a trust, after that person passes, what we're going to be doing is something called trust administration. And that's simply the job of liquidating the assets in the trust and distributing them to the beneficiaries the way the trust says. And it may be something that is fairly short-lived. If somebody says, look, I've got 2 kids, they split 50-50 everything I have, and you know, they can get it right away because they're responsible, they're mature, and doing well in life. That can be fairly quick and easy. Somebody else might say, you know, I've got this one kid over here who, for various reasons, I don't want to give them a large lump sum of money. So the trustee's job is to maybe distribute a certain amount to them over a period of 15, maybe 20 years. And that could become a longer term job for the trustee. 3 most common types of probate in Texas. We have monument of title, and that's going to be where if the only thing that you have is a house that we can't get at. So for example, if a spouse dies and you have access to all their bank accounts, they do a beneficiary designation form for their car, then we can go through the probate process in a little bit quicker manner, in a little bit less expensive manner, called monument of title, where all the court's doing is awarding the real estate to somebody, okay? So it saves us a little time and a little money in the court system. Independent administration is where the executor or the administrator of the will can go off and do what they need, and they don't have to ask the court after that initial time that they go to court. They don't have to continue asking the court for help or for permission to do things. Dependent administration is a worst case scenario. That's usually for people that don't even leave a will behind. And their family, if they want to sell the house, they have to go to court and ask permission. And by go to court, I don't mean just show up when you want to. I mean hire an attorney, file a motion, set a hearing, go to the hearing. If they want to access the retirement accounts, they have to get permission from the court. So that's kind of the worst case scenario there. And that's for intestate probate. Intestate probate is when somebody passes away without a will, and they have to go through the court system without a will, and that's the most expensive, most time-consuming, and most government and judicial red tape circumstance that you can do in the probate court system. And If you want to punish your family members when you pass away, don't leave a will, don't leave a trust, because it's basically punishment to have to do that, in my opinion. So some other considerations. Again, you may not want to give all of your inheritance outright. You may want to do different things over time. There's other things that we need to, we can look out for in here. For example, divorce situations with beneficiaries. Those things can be handled through a trust. Okay. So now, guys, we're here at the end, and I want to let you guys know, again, like I told you at the beginning, we do offer a initial consultation that is complimentary to any individual or any family for the first hour of time that is absolutely free. So if you want to take advantage of that through Zoom, through a phone conference, or if you want to come into the office, and by the way, we have 2 offices. We have one in Southlake, and we have one in downtown Fort Worth. But if you want to come in, we take a lot of protocols. We have plexiglass on the conference table. We can wear masks, and so we take a lot of protocols there. And that being said, I'm going to stop, and we're going to have 10 minutes here, and I want to answer you guys' questions. Okay. I'm going to try and get off screen share here. I think
You're good. It's gone.
I did that successfully, hopefully.
All right, so I think we might have more than 10 minutes worth of questions. I'm just giving you fair.
Okay.
Okay, so first question. If you're on Medicaid, do any legal documents really matter?
If you're on Medicaid, do any legal documents? Yeah, absolutely. I mean, number one, if you're on Medicaid, if you receive Medicaid because you're in a nursing home and you pass away, Medicaid is they have a group called MERP, the Medicaid Estate Recovery Program, that's going to come after your estate, and they're going to try and collect every dime they spend on you. So if they spend $120,000 on you, they're going to try and collect that out of your estate after you pass away, which means it won't go to your kids. It will go to your spouse. Okay, your spouse with the house will go to your spouse, but it will not go to your kids. And so there are things that we can do to avoid that. In particular, if we can avoid the court system when it comes to Medicaid, if we can avoid probate court, MERP cannot collect. They have to collect through the court system. So when I was talking about things like transfer on death deeds, trust, those kinds of devices, that can help us avoid Medicaid's claim for money after we pass away. Number two, everybody, whether you're on Medicaid or not, should have powers of attorney, right? And so somebody may be on Medicaid and it has nothing to do with a mental incapacity. They have physical problems that cause them to need round-the-clock nursing care, but they may at some point develop a mental incapacity. So that's important. Another thing too, guys, is this. A lot of people, another big common misconception is if my spouse is diagnosed with Alzheimer's or my spouse is diagnosed with dementia, then it's game over. We can't sign powers of attorney. We can't sign a will. We can't sign a trust. That is absolutely not true. It does not matter what your diagnosis is. There are people, many people in the early stages of things like Alzheimer's and dementia who are perfectly capable of understanding that if I sign this document, I'm giving my house when I die to my children, or if I sign this document, when I become fully mentally incapacitated, I'm letting my wife make my medical decisions for me. So if you know somebody that receives that kind of a diagnosis, and it's still early, and they still have their mental capacity primarily about them, that's when it's real critical to get in and do things. But yeah, with Medicaid, there's still a lot of things that can really help in that situation. Okay,
so this actually brings up a question I was going to personally ask because you're on this subject. So what I'm understanding, and I'll give you a little bit of background. So my mother-in-law wants everything that she has, which is not a lot, to go to her grandson, my son. She says it's his college fund. Okay. I know she will probably end up on Medicaid. So what I'm hearing you say is it's best to trust anything she has for him. Would that be correct?
Yeah, so I mean, let's say for example, if somebody has $200,000, right, in financial accounts, and just so you guys know, right now for Medicaid, if you're married, the spin down is to $126,000. So you can still have 126 and qualify. If you're single, widowed, something like that, it's 2,000, right?
Yeah, she's
So the only
single.
way to salvage that would be to put it in trust. But you have to wait 5 years. So if the person sets up the trust and puts the money in trust, and then 4 years later, they have to go into care, they are still going to have to pay out of pocket for a year. And then once they hit that 5 years, then the trust will work. So there is that 5-year look back that's real important to remember.
Okay. Cool. All right. That answers my question. I'll be in touch. All right. So my next question here is, in regards to the motor vehicles, what happens if you're leasing your car? What happens to the money still owed on the lease?
No, I mean, really nothing. You just, the family member would just need to return the vehicle with the death certificate, and that should be it.
Okay. Okay. All right. Let's see. Okay. If you move your homestead into your trust, will you still get your senior exemption on your property taxes?
That's a great question. Yeah. So all your property exemptions in the state of Texas under our tax code for our state, all the property exemptions you get now, you would still get if you move your homestead into a trust, if you actually still, if it really is still your homestead, right? If you haven't just moved off to Florida, but you still have the property, you would sign something stating that with the county tax appraisal that, yeah, this is still my homestead. We'll take your word for it. But the answer is yes, as long as it does in fact remain your homestead, you get those exemptions.
Great. Okay, so how do you find out how to donate your body to science if that is your choice?
So I think the best way to do that is to go ahead and research different hospitals with medical schools. Here locally, UTD, or wait, yeah, UT
Southwestern?
Yeah, UT Southwest Medical School. A lot of my clients will contact them. They actually have forms that you can go ahead and fill out. So I would say the best way to do it is to contact a medical school of your choice and let them know you'd like to leave your body to their program after you pass, and fill out their forms. And in that, for my clients who have the burial and funeral instructions, they'll put that in there so that their family knows. And they'll say, you know, I already have a prearranged plan with UT Southwest or with some other medical school. And now if you don't feel like going and working that out with the medical school ahead of time, and you just want to leave those directions to your family, you know, then they can attempt to get that done for you after you're gone, but I don't really recommend it. So I think it's best to get that arranged with the medical school now, if that's what your wishes would be.
Okay. All right. Next question is, as time goes by and there are changes needed to be made to a trust, can a person just retype a page, or does the entire thing have to be redone? And if it does, how much would that cost?
Okay, so no, you don't have to redo the entire trust. So that's good news. Number two, no, you don't want to just simply retype a page. I mean, yeah, you need to do what we call an amendment. And we strongly recommend doing it with an attorney, an estate planning attorney, so it's done the right way, because it needs to be done the proper way to actually work in the long run. And it costs a few $100. It's much cheaper than just setting up a whole new trust. So don't do it yourself, but also you don't have to go hire an attorney and just throw everything out the window and redo everything. We can do what's called an amendment, which is relatively inexpensive and relatively quick.
Okay. All right. Trisha asked, what is a MERP? But you kind of already explained what that is.
That's the Medicaid Estate Recovery Program that will attempt to collect every dime that they spend on you after you pass away. and after your spouse passes away.
Okay. All right. So we may need to unmute this person to get a little bit more clarification, but if you need more, let me know, Brandon.
Okay.
While a spouse is recovering from a serious brain injury, can the other spouse cover the family needs temporarily, and must our lawyer be involved?
Well, okay, so what does that mean by, I guess I would need some more clarification on what does that mean by cover the family needs?
Right. Paulette, if you want to unmute yourself and kind of give us a little more information so he can address that.
Brandon, we've probably already been in touch because we're clients of yours. Joe is temporarily in Texas rehab with a brain tumor.
Okay.
That hopefully with chemo will take care of everything. And my adult son is helping me take care of the bills. So I just carry on as if Joe is here and pay the bills and contact the bank and do all that.
So first thing is, does Joe currently have his mental capacity?
No.
Okay.
No, he has no, we have aphasia issues, but no, he's in, yeah, no.
Okay, well, I'm sorry to hear that. And
Yeah.
do you guys have the powers of attorney, correct?
I guess so. It's in that booklet that you helped fill out.
All right, well, so
One
I would
of those,
recommend,
you don't need it if you don't need it kind of thing.
number one, I would recommend, normally when this happens, so normally when this happens, I'm not talking to somebody on a large group Zoom meeting, but that's okay. But if you want to call the office and schedule a phone conference or to come in, I can guide you through the documents you need. But
Okay.
yeah, you want to use the powers of attorney that you have, yes, to manage any accounts in his name. And so yeah, you want to keep carrying on the way you normally would even before this happened, but you're going to need, you may need the powers of attorney for any accounts that are not joint. If there's financial accounts in his name or income that comes in his name, that's probably, you'll need the power of attorney for that. But Paulette, if you want, please feel free to give us a call and we can have a conversation about that, okay?
Yeah, okay, well, and I encourage everybody to, one thing I've learned is I didn't have access to my husband's emails, and all the things from the hospital and our doctor go to his email, which means I couldn't get the information because I didn't have access to, everything's on, so email wise, I highly recommend you share your passcode to your spouse.
That's a great idea. Or I have some clients too, they'll set up a joint email and they'll use that for things like that. So that's, yeah, but that's very good advice.
Lesson learned, I'll tell you.
Sorry.
Okay, thank you. Can everybody keep your fingers crossed, please? This is a crisis for us, and we're hoping he comes out really well.
Yes, we wish him
We'll do that.
recovery and best of health to him. That's a tough situation.
I'll come back on Zoom and cheer, let me tell you.
All right. I hope so. I hope that happens.
Okay, thank you, Brandon, very much.
Yeah, thank you so much, Paulette. So sorry to hear about that.
Yeah. Well, I drove the Corvette the other day for the first time.
Well, that's good.
Speaking of motor vehicle.
The silver lining.
That's right. Okay. So our next question moving on is, I have life insurance as well as IRAs. Is it best to leave life insurance to my family and IRA funds to charities?
Say that again. Run that by me one more time.
So the person said that they have life insurance as well as IRAs. Is it best to leave life insurance to my family and IRA funds to charities?
Well, so that depends. I mean, I'm not recommending anybody necessarily leave anything to charity, but if you want to leave some things to charity and you want to leave some things to your family, that's probably a good idea, particularly if they're traditional IRAs. You need to pay, the income tax would have to be paid on that as it's withdrawn, even after the person passes. So the insurance would pass without any taxation to your family. So I don't really have, I mean, that depends on different things, but what you're trying to accomplish, But in general, my takeaway from that would be life insurance will pass without any taxation. Retirement plans, while they may not be hit by the death tax, or what we call the estate tax, they will be subjected to the income tax that the person would have paid when they were alive. So just kind of keep that in mind.
Okay. All right. So we had someone ask, what is the Ladybird law?
Okay, so Ladybird deed is very similar to transfer on death deed. And basically what it's doing is it's saying that you have a life estate in your property, in your real property until you pass away. And when you pass away, ownership converts to your beneficiary. So it could be your spouse or your kids. And again, it allows us to avoid the court system. And which in Texas, for the entire history of our state until 5 years ago, you could not do that unless you had a trust. Now you can with that deed. And it's very similar to the transfer on death deed. And it also allows us to avoid MERP if somebody's on Medicaid.
Perfect. Okay, great. All right. It looks like I don't have any other questions coming through, so I'm going to do my Facebook Live closing really quick, everyone in Zoom, and then we will go off and we will give Brandon his big round of applause. So thank you, everyone on Facebook, for joining us today. All my people in Zoom, please do stick around. We have two $25 gift cards to give away today from our presentation. If you are watching live on Facebook and you would like to join us in the Zoom and be able to ask questions or have a chance to win prizes, please do register for our events on celebrationmagazine.com. Thanks so much, everybody in Facebook land. We will see you soon.
Bye, guys. Thanks so much for listening. Thank you.
Thank you. Thank you.